Hello everyone, welcome to CashcroftTV. My name is Kalen Ashcroft. Thanks for watching this video on Guide to Legal History and Historians, where we will be covering the Oxford Handbook of Legal History, edited by Marcus D. Dubber and Christopher Tomlins. Today we'll be covering chapters 7 and 8 by Laura F. Edwards and Roy Kreitner, respectively. However, these videos do not need to be watched in order, so feel free to jump around, pick the authors you prefer or the topics you prefer. I'd like to open this video, as I sometimes do, with a book endorsement, or rather two book endorsements. That's firstly Democracy in America by Alexis de Tocqueville and The Old Regime and the French Revolution by the same author. They're just absolutely fantastic, and he's long dead and no one's really endorsing them, but I think if you're interested in law or politics or sociology, and as relates to this video, they're absolutely fascinating. And even if you're not particularly fascinated in the United States or France, it covers many other geographies too. It's relevant to Canada, the UK, Germany, and the EU generally as well. So without further ado, we'll begin this video on Laura F. Edwards and Roy Kreitner, and at the end, like in the style of Plutarch's Lives, we'll do a quick comparison as well of the two. So this is we'll start with Laura F. Edwards. So this is in the part 2, Approaches Conceptualizing Legal History, chapter 7, Law as Social History by Laura F. Edwards. A little bit about this author. She's the class of 1921 bicentennial professor in the history of American law and liberty and professor of history at Princeton University. She received her Bachelor of Arts in American Culture at Northwestern University and her PhD in history at the University of North Carolina, Chapel Hill. Before becoming a professor at Princeton University, she taught at Duke for 20 years. As well, she was also an assistant professor at UCLA and University of California, Los Angeles, and an assistant professor at University of Chicago, both as an assistant professor in history. She has 4 books, however, she's working on 2 new ones, and she has won numerous awards, including the Southern Historical Association's Charles Sindor Prize for Best Book in Southern History, as well as the American Historical Association's Littleton Griswold Prize for Best Book in American Law and Society. Her research interests these are in alphabetical order: African American citizenship, constitutional history, consumer history, cultural history, gender and sexuality, history and public policy, labor history, legal history, material culture, political history, slavery, and social history, which will be predominantly the topic of this chapter itself. She often focuses on the 19th and 20th century. Some of her books include A Legal History of the Civil War and Reconstruction, A Nation of Rights, published in New York by the Cambridge University Press in 2015, as well as The People and Their Peace, Legal Culture, and the Transformation of Inequality in the Post-Revolutionary South, published in Chapel Hill by the University of North Carolina Press in 2009, as well as The Scarlet Doesn't Live Here Anymore, Southern Women in the Civil War Era, published in Urbana by the University of Illinois Press in 2000, as well as The Gendered Strife and Confusion, The Political Culture of Reconstruction, published in 1997 also in Urbana by the University of Illinois Press. She is currently working on 2 new projects: Only the Clothes on Her Back, Textiles, Law, and Governance in the 19th Century, to be published by the Oxford University Press, but it's under contract presently, and America's Unintended Journey, The Civil War and Reconstruction, to be published by the University of North Carolina Press, commissioned and under contract. So her chapter is chapter 7 of the Oxford Handbook of Legal History, titled Law as Social History. So her introduction notes that she discovered legal history during her dissertation, during her PhD studies on social and political change in North Carolina during the Reconstruction. However, actually the first sources, she used law as sources only, such as local court records, which provided surprising evidence of conflicts. Furthermore, it evidenced racial violence and labor arrangements, and domestic violence and sexual assault, spillages, and all the spillages into the borders of households, farms, and neighborhoods, into the courts, and often these were quite graphic, and it shattered her preconceptions of Victorian America. However, she was focusing solely on legal sources and not, as she says, engaged in legal history. However, she says she was urged by one of the editors of this book, so I'm guessing it's Christopher Tomlins. However, it could have been Marcus D. Dubber because she references both in the chapter, but either way, she was urged by one of the legal historians, who's one of the editors of this book, the Oxford Handbook of Legal History, and to engage in legal history because not her current work, but focusing solely on just history or law separately, missed the mediating power of law and ultimately the significance of some of the materials. This is a difficult form of work, law as social history, because it covers many different periods and many different varieties of law. But for the purpose of her chapter, she focuses on two related themes embedded in the relationship between social history and legal history, as well as focusing on the long 19th century, but however, these principles are generally applicable. So first, legal history requires a broader understanding of law than other historical fields, beyond written records, legal officials, and designated institutions, into the realm of social history, and even into the rural byways and city streets. So using law as social history looks beyond the most popular sources. Legal history also changes our view of social history because it exposes law's presence in relationships to areas most historians imagine for far distant from anything legal. So social history broadens our perspective of the law and legal history. So the next chapter is, where is the law? So outside legal history, the U.S. Constitution, i.e. states and federal governments, share the authority, are the most common sources, and it's commonly thought that at the end of the Revolution is the chronological beginning of legal history. However, she points out by focusing on law as social history, they can draw a lot more from the colonial past. Furthermore, more weight is given to texts, and students focus on appellate decisions, treaties, and by trained legal professionals. However, they don't focus as much on practice and operation, which leads to the positivist approach of using social history, which is a common theme throughout many of these chapters. Furthermore, it makes it seem more simplistic, just focusing on these sources, and the population. It must be noted that law as social history is important because most of the population lacks standing to access these institutions or access the courts, such as women and African Americans often didn't have access to courts. So this law that a lot of people study in legal history is missing a big portion of society. Legal history focuses also on state building, and however, this provides an opportunity for linking the colonial to the post-revolutionary past and beyond the boundaries of the state. Law and society bridges this gap. Mixed success, however, has been found sometimes in applying social history, in that, for example, Robert Gordon's, in his critical legal history, says society, place, and law responds, in that there's a sharp line between society and law. However, we can see that they can be merged. Hendrik Hartog's classic article, Pigs and Positivism, is evidence of the use of social history. For example, at the time, in New York City streets, there were a lot of pigs roaming around, and society voted to, or the upper class of society tried to get rid of these pigs, so it was banned. However, in practice, nothing actually changed. So if you looked only at the laws, you'd be like, oh wow, like pigs have been banned from the New York City streets. However, if you focus on law and society, you'll see that the law actually did very little, but society had so much shifted its preferences at the top echelons, or the most people with the most access to law. There's also found to be some capriciousness in this, and however, overall it's not showing the weakness of law, but the power of the law, in that the streets had power to make the courts change, or the upper echelons had power to make the courts change the law. So it's still evidencing the power of the law. In 1984, Stanley Katz called on historians of colonial American law to drop prevailing concerns of ultimate emergence of state. And in 1993, in the William and Mary Quarterly, he wrote Law and Society in Early America, in his article titled Law and Society in Early America. Law is a complex, pluralistic, asymmetric, gendered, and multicultural set of systems, messy systems, if indeed the term system can be applied at all. So even back in 1993 or even in 1984, Stanley Katz was calling for a more social approach to legal history, which Laura F. Edwards advocates. Furthermore, it's part of a larger movement by connecting social history to this. It connects North American colonies to other parts of the globe by applying social history, such as law and colonial culture, according to Lauren Brenton, where there's in Lauren Brenton's Law and Colonial Culture, she shows that legal pluralism characterized the colonies, which draws a link between the colonies and the colonizers. So it's found there was pluralism also, for example, in the United Kingdom. She notes, however, here that must distinguish legal history pluralism. So commonly pluralism is focused on the different forms of government, for example, church and state. However, here it's referring to pluralism as in different legal systems working simultaneously. England, for example, had the church, the king, parliaments. However, in US, they had different geographies. For example, even across different roads as boundaries or as rivers as boundaries, there would be different laws or different societal preferences as well. Philip Stern shows legal pluralism in corporations in the US had legal authority in the company state, further evidencing a plurality and therefore a need for social history. And in The Many Legalities of Early America, which was edited by Christopher Tomlins and Bruce Mann, Legal History Before the Revolution, it shows a strong sense of pluralism and a need to study social history prior to the revolution, and therefore bridges the gap between the two. And there she's referencing Christopher Collins here, so Tomlins, pardon me, so perhaps he was one of the ones who inspired her, but as we'll see, she later references Marcus D. Dover as well. So, in fact, also I said this is chapter 1, it's all one big chapter in this, so I'm not going to be having too many gaps, but pardon me for that. She then references Holly Brewer's coverture of women in America in the Transformations of Domestic Law. So coverture was due to political conflicts with England. So just by looking, however, at the coverture, you might think that it was the heads of households that caused it, but there was also the conflicts with England and the social pressures to create coverture in the United States, which needs to be addressed and therefore yields a positive approach and the necessity of law as social history. Furthermore, there's coverture varied over time and place. For example, in Cornelia Hughes Dayton and Linda L. Statz, Ellen Hartinger's O'Connor, such as in the work of all of these individuals, show that coverture varied over time, such as Cornelia Hughes Dayton, Linda L. Statz, Ellen Harrington, O'Connor, and Serena Zabi. Furthermore, coverture, if you don't know, is the merger of female and males in a legal sense, but just focusing on coverture or what's written on the laws misses a lot of the picture, therefore the need for social history. In Dayton's example specifically, in Dayton's example as well, they show in Boston there was a Puritan provincialism where they had what's called the warning out, where they say if you do not leave Boston you have to leave Boston in 14 days. However, if you just focus on the law, that's what it might appear to be. However, it was a form more of inclusion rather than exclusion, because it is showing that the poor need the relief of the state, and those should be kept out. So, but just by looking at the law, it might seem like an exclusive thing. However, it misses the social context, and therefore, once again, evidencing the need for the study of law as social history. Once again, she references Christopher Tolman's Freedom Bound, which is one of his noted great works, which covers the colonial period to the Civil War and seamlessly connects the two through, and thus showing the necessity of social history, because before, in colonial past, there were laws, but they were often very restricted to states and not as formalized, but therefore evidencing the need for social history if you want to study that and bridge the two together. In Greg Ablavarski's Savage Constitution, it argues that the federal government was made stronger in the Constitution in light of indigenous threats. So another need for social history. If you just looked at the Constitution, you wouldn't understand why the federal government was relatively stronger than the state government unless you understood the social context and that there was an indigenous threat. Furthermore, in Gauthan Rao and Karen M. Taney's National Duties and States of Dependency, the federal government was not able to control the duties, customs duties, and therefore permitted the states to have that power. But if you just read the laws, you wouldn't recognize why the federal government gave up these powers, especially considering they wanted to have these powers, but they just couldn't. Therefore, the necessity of the social context. Then she references Marcus Dubber, so it could have been Marcus Dubber who motivated her to get into this field as well, in his writing on the police power, where he applied modern police expansive authority, where modern police have given expansive authority and shielded from public regulation. This is, once again, due to the social context, but if you just looked at the laws, it wouldn't be fully understand. And it shows the surprising effect that society can have on the police, but in this sense, it's in the negative. So social history is both positive and negative. And also with the pigs as well, they failed, but they caused the law to be created in that sense, even though it was kind of made against society. In Kevin Butterfield's The Making of Tocqueville's America, which is, as we have here, Democracy in America, one of the best books I've ever read, quite frankly, and I've read a lot of books. He says that America was made bottom up from the state to the governments, and therefore the necessity of studying society rather than studying from a top-down approach, which, as we'll see, is a more political approach. And so a bottom-up approach, as Tocqueville would probably advocate too, would be a societal approach. And she also references Saring Beringer Gordon, The American Supplement, the importance of church to provide access to the law, particularly dispossessed black people. So, dispossessed people meaning black people. So if you just looked at the laws, or if you didn't study the necessity of the church, or didn't study the church's interworkings, you'd miss a lot of aspects of the law. In Edwards' The People and Their Peace, it shows the power of municipalities and counties as a source of law from society to revolution. So once again, the society can cause these laws, and therefore necessitating the need for law as social history, as a form of study. And later in her book that she is producing, Only the Clothes on Her Back, it gives to often marginalized people, or people with only tenuous claims to property rights, could actually make claims to property in the case of such things such as textiles in local courts. So it wasn't as black and white that women didn't have any control over their property, but in certain areas they actually did. But if you didn't understand the social history, then it wouldn't make any sense, or you wouldn't even know of this. And as the 19th century becomes more connected with the past, the Civil War has taken on more of a has taken on more of just a watershed in terms of a change of law, but a lot of these laws had already existed. So just focusing on post-revolution would be wrong, but you need to study the social history, particularly prior to the revolution. Furthermore, social institutions such as citizenships took more weight. For example, in William Novak's The Legal Transformation of Citizenship. So citizenship changed drastically over time. However, it was caused by social underlying shifts or currents. Furthermore, she says, law does not control society, nor does society drag law behind it. So they're two inseparable elements of the law. My apologies, my phone rang. So law has made a shift to become more bureaucratic, and there have been stronger institutions. However, studying society is still important, and thus law and society is still important as a study. And although legal history does encompass society, economy, and culture, it's more ubiquitous and has become more powerful and more difficult to categorize, especially if we include social history. And as it seems from this last section, as we look further back in time, the necessity of social history might be perhaps more important, or that would be a good question to ask her, or is social history equally as relevant? But I think perhaps it is equally as relevant. Then lastly, she concludes with some quotes. Law was not the authority to which people deferred, it was the authority they made. And therefore, she concludes saying, it is impossible to study American society without it, meaning without law. So, on to the slide, we have here in the top right the logos Princeton University, in the top left the university she's a professor at, top right Duke University, the university she taught at for many years, the University of North Carolina, where she received her PhD, and Northwestern University, where she received her bachelor's. Research interests: African American citizenship, constitutional history, consumer history, cultural history, gender and sexuality, history and public policy, labor history, legal history, material culture, political history, and social history. This chapter was in Section 2, Approaches Conceptualizing Legal History, Chapter 7, Law and Social History, by Laura F. Edwards. The institution she's at is Princeton University. Her position is Class of 2021 Bicentennial Professor in the History of American Law and Liberty, and a Professor of History. Suggested readings: A Legal History of the Civil War and Reconstruction, A Nation of Rights, published in New York by the Cambridge University Press in 2015. The People and Their Peace, Legal Culture and the Transformation of Inequality in the Post-Revolutionary South, published in Chapel Hill, the University of North Carolina Press in 2009. Scarlet Doesn't Live Here Anymore, Southern Women in the Civil War Era, published in Urbana by the University of Illinois Press in 2000. And Gendered Strife and Confusion, The Political Culture of Reconstruction, published in Urbana and University of Illinois Press in 1997. The quotes: The law changed what I was seeing in the sources, revealing the ways that people constructed their stories to fit within the legal process, and also understand their conflicts in legal terms even before they entered the court. Legal history, in other words, changed the way I saw social history. Furthermore, it is impossible to study American society without legal history, as one of the last quotes she has. And as the work in legal history shows, people in the 19th century did not see law as something abstract, arcane, and inaccessible. Instead, law infused all aspects of life. So I hope this section gave you a little overview of law and society and social history, and perhaps a fascination in the work of Laura F. Edwards. Moving on to Roy Kreitner's section, Chapter 8, Legal History as Political History. So a little bit about Roy Kreitner. He's a professor of law, the Buckman Faculty of Law at Tel Aviv University. He's focused on private law, legal history, and law and political thought at Tel Aviv, and he's worked there since 2001 as part of the faculty. He received his doctor, his SGD at Harvard Law School in law, his doctorate of law, and also he received his Bachelor of Law and Master of Arts in Comparative Literature and Semiotics from Tel Aviv University, as well as his bachelor's degree from Brown University. He was previously a visiting professor at University of Virginia and the University of Toronto, as well as a visiting researcher at the Institute for Global Law and Policy at Harvard Law School. He was a fellow at the Radcliffe Institute for Advanced Study at Harvard, as well as an American Council for Learned Societies. He is the author of Calculating Promises, The Emergence of Modern American Contract Doctrine, published by the Stanford University Press in 2007. So in this section, it's part of Part 2, Approaches Conceptualizing Legal History, in Chapter 8 of the book, Legal History as Political History. He says he's thankful for helpful conversations on ideas that became the chapter to Yishai Blank, Christine Dezen, Marcus Dubber, Ron Harris, Shai Levy, Asaf Likovsky, Doreen Lustig, and Christopher Tomlins. So he says, he starts by opening, legal history as political history has an unfamiliar ring, however, but one that calls up a number of related phrases, and therefore it's a form of interdisciplinarity, and this has been the case for decades. Example, law and history, law and politics, law and is and as literature, law as economy, law is politics, and critical legal histories. But the focus of the chapter will look more narrowly at specifically what is law as political history, and there's little to say about the theory and legal history as political history, although it could be an axis on which all these other things can move. What he tries to do is get a specific definition for this. So there are two debates that underlie this. One, political history meaning differentiation from social and cultural history, and meaning the political history differentiating it from social and cultural history, as well as law and politics, especially critical, the relation between law and politics, especially in critical legal studies, and therefore what is the view of critical legal studies on the view of this relationship. The chapter will open by waiving a brief preliminary questions, and then state an abstract claim, then lead by some examples, and then which will be the heart of the chapter, and conclude by some questions. So part 1, political history generally is a top-down approach, often seen as a form of hero worship, where it's focused on office holders, leaders, and parties, and constitutional changes and revolutions and major events, whereas social and cultural history is focused on groups and unnamed individuals. Frederick Logval's and Kenneth Osgood's The End of Political History, published in the New York Times in 2016, was an op-ed saying that legal history was declining in popularity in law schools. However, he's not focused on, although it is still resilient in law faculties, it's usually only on major political events. However, for the focus of this chapter will instead turn to a different definition. So critical legal studies fails to distinguish law from politics, and much energy in the 1970s and 1980s was dedicated to critical legal studies, but it lended undue legitimacy to legal terrain and ideological. Overall, he thinks it's right that law and politics should be somewhat merged. However, mainstream theorizing of law has a tendency to limit to institutional imagination, according to Roberto Unger. However, he says it doesn't need to be completely split, law and politics. However, there's a need for a distinction to reassert the urgency of politics. So then he moves to part 2, which is the argument abstracted. So this is the crux of his argument. What is legal history as political history? In lieu of developed analytic, he presents what he says is we'll focus on what to look for. So what is legal history as political history? What should we be looking for? And he says what it is it traces the way jurisprudential change varies the terms of social interaction. And therefore it's still a top-down approach, but how it affects society. That's the way I envision it. Although it can be a can of worms, however, because none of these terms have an uncontroversially fixed definition. To kind of elucidate this, he uses the example, let's say you change the speed limit from 100 to 110 kilometers per hour. The law changes, but not the law's function. So this would not be legal history as political history. On the other hand, if you use cameras to monitor movements, it affects freedom of movement and privacy, which is the change in the way law functions, but also it has an implication on society, and it's political. Therefore, it's legal history as political history. He doesn't want to get too caught up in taxonomy, and that's the focus of op-eds, and although no funding does rely on defining this strictly legal history as political history, he still thinks it's important to define it as such, as if it affects societies, it's important and political. Usually, these changes are more slow. There's often a methodological issue in that there's layering more often than replacing. So looking at laws, there's often different layers, so that's often an issue even with his definition. But nonetheless, he moves into some very strong examples that help elucidate what is legal history as political history. So often it involves a shift in law through politics, usually often patriarchal to liberal. So there has been a shift from patriarchal to liberal, and a lot of these document that. So he begins perhaps with the most self-conscious and theoretically engaged in past decade, which is Christopher Tolman's Freedom Bound, which was also referenced by Laura F. Edwards. In this, he discusses two elements, among many other things, to distinguish the traditional histories. In that, one, it does not comply with the implied Whiggism of standard labor history. Instead, it was traditional racial alternatives, and they're a radical alternative. So in terms of labor laws, it wasn't just service turning to labor. It wasn't an instant switch in terms of laws. In fact, there were much overlapping, and we kind of get into this discussion of pluralism again. Secondly, it also discusses covenants, contracts, and free labor were never encompassed the whole of world of work, and instead atop of the social and legal relationship of households, and therefore also driven in some ways by the patriarchy. So once again, nuance, but it's legal history as political history because it's not just it's not a change in form, but a change in its underlying roots. Then he moves on to Shea Lavy's The Modern Art of Dying, which is a more localized example that focuses on jurisprudential changes in euthanasian laws, where, interestingly enough to me, I didn't know that euthanasia was originally put forward by the Protestants and some of the Jewish community against the Catholic Church. However, it later switched over to become more of a medical concern, in that it was a way to help prevent people who kind of needed to die. But then it started to become took a more legal approach in the 19th and mid-20th century. And although it could have gone through the common law route, which was, for example, in the death penalty used, it took a regulatory regime to change it. So it changed, the possible form of law changed through politics. So once again, it wasn't just a change in law, but a change in form, and therefore legal history as political history. He then moves to Barbara Welk's example, Recasting American Liberty, which covers 1965 to 1920, accidents and their implications on the relationship between individual autonomy and liberty. Namely, there were a lot of changes in railroads and streetcars, and cars specifically that required more regulation but less autonomy for the individual, for example, driving licensing and speed limits. And it's quintessentially a legal history because a lot of this was driven by municipalities that affected the legislators. So this is a bottom-up approach, but still legal history as political history. Furthermore, for example, women were in some ways treated to be less trustworthy with some of these things. So once again, a political undertone and a change in form. Then he moves to Dorian Lustig's Veiled Power, International Law and the Private Corporation, published, covering 1886 to 1981. That international law under the Westphalian premises, which is focused on sovereign states, and only after popular outcries in the 1970s and 1990s caused it to focus on corporations. So a shift in Europe predominantly towards a more corporate focus, which is a legal history as political history, because it's not just a change in specific laws, but a change in its form. Furthermore, there was a co-development of imperial states and multilateral corporations, where the multilateral corporations started to get more market share, not to make a pun, I suppose. But it's still nonetheless a political legal history. Lastly, he moves to the older but groundbreaking legal history as political history work by Dirk Hartog's Public Property and Private Power, where there was a shift of government governing through its private estate to through a public bureaucracy to provide public goods for consumption. So there were two visions of government. In one, that property, and if the government owns the actual assets, it has a direct sense of responsibility. For example, a city creates a water lots or grants water lots, and then it gets ownership. There was thought that it would have more responsibility. However, there was a shift over time towards more bureaucratic management, where legislatively directed and financed through taxation. However, it was led largely by the private sector and gave up the autonomy, but it gave more innovation. But this was a change in legal history as political history, because it's a change not just in the laws, but in the change in the form. In overall, he says the 19th century to the moving to the what shifted towards more liberal, and the 21st century is more liberal. So these are political changes, that undertones that can be observed in all of these examples. And often they've been guided by international organizations such as the World Trade Organization, Basel Accords, IFRS, accounting standards, Financial Action Task Force, and the environmental soft law. Soft law is interesting. It's kind of Joseph Nye, a really great intellectual from Harvard University, talks a lot about that. But nonetheless, it's been shifting away perhaps from the traditional political institutions to more auxiliary institutions. And once again, legal history as political history. All large formal and institutional change ways the laws work, and they also have this is once again a top-down, generally a top-down approach, and how it affects society, whereas laws, society would be society going up into politics. The choices that he says, perhaps there might be criticism that the examples that he uses are too eclectic or too broad, but then he gives a counterexample. For example, Christian Vinel's The Employee, a Political History. So it sounds on face value like legal history as political history, where the contents of who was considered an employee changed over time. However, its workings, function, and form stayed intact, and therefore would not qualify as legal history as political history. Then he moves to the conclusion. So the argument for an idiosyncratic yet general view of legal history as political history, in that legal history, his proposal of this is both idiosyncratic and general. And legal history is attentive to changes in forms of law and legal reasoning rather than content. So legal history as political history. So it's focused on changes in form, but not necessarily, changes in content are also implied, but not strictly changes in content. Example, shift to occupational health and safety administration, relying on experts from judges rather than relying on judges. So moving away from a political institution to a lesser political institution, or an auxiliary political institution. Furthermore, he notes when language changes, political horizons change with it. So it's important to focus really on the words, and therefore you can derive legal history as political history. Then he finally concludes with one major pitfall and three modest advantages of his definition of legal history as political history. The major pitfall is it says nothing about the issues that makes politics urgent, such as it has no direction, like it does not focus on race, gender, class, or anything of that sort. So it has no direction, but that could be a pitfall of this type of legal history as political history, as it's completely observational. But some of the three benefits, modest benefits he calls them, is that it looks beyond the world leaders and political parties, so it starts looking into auxiliary organizations and sometimes even society and all other many other aspects of the political realm. And then another benefit is that it distinguishes general political action from legal history as political history. So it changes in the conceptual use of the law is key, and it's important if this is neglected. So it has a positivist aspect, which is a general theme in this book. And thirdly, a third modest benefit is that it puts the spotlight on power and limitations of legal change, and that form may outlast goals. So do not determine a change in the law and the form do not determine once and for all the direction and the development of law or its objects. So it recognizes that law is a continuously changing process affected by the political nature of society. So that is that. My apologies if I was speaking quick, but there's a lot of content here and a lot of really strong examples, and that's why I suggest that you buy the book. Once again, I've not been endorsed or vetted by the Oxford University Press or the editors. However, I have been told I could produce this video as long as I'm not giving too much text. So moving to the slide, in the top right we have the Buckman Faculty of Law at Tel Aviv University. Below that, the Harvard Law School logo, where he received his Doctorate of Law, and Brown University, where he received his Bachelor of Arts. This section is part 2, Approaches Conceptualizing Legal History, Legal History as Political History. The institution he's at is Buckman Faculty of Law at Tel Aviv University. His position is Professor of Law. His research interests are private law, legal history, law and political thought. Suggested readings include Calculating Promises, The Emergence of Modern American Contract Doctrine, published by the Stanford University Press in 2007, Legal History of Money, Part 8 of the Annual Review of Law and Social Sciences, pages 413 to 431, published in 2012, and On the New Pluralism and Contract Theory, Part 45, published by Suffolk University Law Review, pages 915 to 933, published in 2012. To the quotes, legal history as political history has an unfamiliar ring, but one that calls up a number of related phrases that have peppered legal history and its forays into interdisciplinarity for decades. When legal history is attentive to changes in forms of law and legal reasoning rather than the law's content, it is legal history as political history. So that is his definition of legal history as political history. And lastly, a shorthand for legal history as political history might claim that law as political history traces the way jurisprudential change varies the terms of social interaction. So that is Roy Kreitner's chapter, and I hope you enjoyed it and are interested in his form of scholarship. I think I would advocate studying both social history and legal history as political history would be the best way of approaching legal history as a form of scholarship. Moving to the comparison in the style of Plutarch's Lives, not like these two are actually direct competitors or anything of the sort, but I think it's a good way to learn about people through comparing them. So from the start, Laura F. Edwards is at an American institution and has predominantly stayed at an American institution for most of her career, or if not all of her career. Roy Kreitner has spent a lot of time in the U.S., however, he's at an Israeli institution. However, they both wrote predominantly on American history. Obviously, Laura F. Edwards is in legal law as social history, whereas Roy Kreitner's chapter is on law as political history. Laura F. Edwards' approach, social history or cultural history, is generally a bottom-up approach, whereas Roy Kreitner's, although he does evidence some bottom-up approaches, law as political history is generally a top-down form of research, although he does advocate for looking away from this. They are both readers and writers, however, considering how many examples they used in their chapters. However, Laura F. Edwards has produced more books, but that isn't to say Roy Kreitner won't in the future. And on one hand, Laura F. Edwards, I guess one of the main points of the chapter is that Laura F. Edwards is more showing what law as legal history is, whereas Roy Kreitner is kind of creating his own sort of definition of legal history or legal history as political history. So that is the video on Laura F. Edwards and Roy Kreitner, Law as History, Chapter 7, and Legal History as Political History. I hope you enjoyed and continue to support. Thank you so much.